Sean Diddy Combs has just filed a brand new bid to get out of jail before his sentencing in a few months. From arguing he shouldn't be locked up for his swinger lifestyle, to highlighting the atrocious conditions at the MDC, to addressing allegations of violence, he is fighting for his life in this new letter to the judge. Could it work? Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Will Sean Diddy Combs be released from jail? I know I've asked that question before so many different times here on Sidebar, but we have right now a brand new request from his legal team, a brand new filing from his defense team arguing for why he should be released now after that monumental verdict in his criminal case several weeks ago. The circumstances have changed, and I will tell you what. We did an interview a few weeks back that kind of previewed why and how Combs could be released. It was a bail bondsman that is apparently working with Diddy's team behind the scenes. I'm going to get to that a little bit later, but what I want to talk about right now is this latest letter from the defense to the judge overseeing this case, Judge Arun Subramanian. Remember, this comes after a jury of Combs' peers found him not guilty of racketeering conspiracy, not guilty of 2 counts of sex trafficking, but they did convict him of 2 counts of transportation to engage in prostitution. He's set to be sentenced on October 3rd. Technically, he could face up to 10 years in prison on each charge. Highly unlikely. I think maybe you might be looking at somewhere to 2 to 5 years potentially, but he could also get time served and be released, although that also seems unlikely. I'll talk about that a little bit later too. But initially, after the verdict, right after the verdict, his defense team petitioned the court that he should be released. He was just acquitted of some very serious charges. The judge denied it. The judge denied Combs bail once again. And remember, this comes after he was rejected bail multiple times since he was arrested back in September of 2024, highlighting the severity of the charges, the violence, and so forth. But now, this is different. Now, what is the defense arguing? I'm going to go over all this in the new letter. I'm going to give my take at the end about whether or not it's going to be successful and whether or not he will actually be released before sentencing in October. So, the defense begins by arguing that Sean Combs should be released in advance of sentencing, and the court has the power to do this. They have the authority, among other things, because you can clearly show, quote, that there are exceptional reasons why such person's detention would not be appropriate. So, what are those exceptions? What are those reasons? What are those circumstances that are exceptional? They highlight several things that we're going to get into. That the charges he was convicted of, we're going to call them the Mann Act violations, that's what it's called under the law. They're not as severe, they're not as egregious as other convictions in other cases. That the sheer fact that he's locked up at the MDC, the Metropolitan Detention Center, for the past 11 months, that in and of itself is a reason for him to be released. These are all exceptional circumstances, and I'm going to get into all the arguments. But first, they highlight the standard, and they argue that to be released under federal law, you need to show 2 conditions. First, the district court must find by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. Second, it must be clearly shown that there are exceptional reasons why such person's detention would not be appropriate. Now, clear and convincing evidence is a lower standard, by the way. It's not like beyond a reasonable doubt. Anyway, basically, you have to show he's not a flight risk, he's not a danger, and you have to show there are particular, exceptional, unique reasons for why detaining Combs is wrong. We're going to start with the exceptional reasons justifying his release. And they begin by trying to define, well, what exactly is exceptional circumstances? What does that mean? And they argue that case law suggests a court has a lot of discretion to determine whether a particular set of circumstances qualifies as exceptions. And they say, look, Sean Combs, his case, so different from other ones. There has never been, according to them, a Mann Act prosecution like this one before. And this is how they lay it out. Quote, there has literally never been a case like this one, where a person and his girlfriend arrange for adult men to have consensual sexual relations with the adult long-term girlfriend as part of a demonstrated swingers lifestyle and has been prosecuted and incarcerated under the Mann Act. Combs and 2 of his longtime girlfriends had a private, intimate life that is not uncommon today. They're talking about Jane and Cassie Ventura. Quote, it may not have been common on June 25th, 1910, when the Mann Act, or as it was originally called, the White Slave Traffic Act, was passed, but attitudes about sex and morality have come a long way in the last 115 years. It is worth noting that when the Mann Act was passed to protect the morals and decency of America's women were not allowed to vote. As noted below, perhaps due to the troubling background of this statute, whose history is rich with both racism and misogyny, the Department of Justice has limited its application to those people profiting financially from the business of prostitution and not using it to prosecute consensual adults for their own lifestyles. By the way, we covered this on a previous sidebar. The defense made an argument months ago to have these charges thrown out, called it basically racially motivated, that it was strange that it was being used against a successful black man. That argument didn't work. He was ultimately prosecuted and he was convicted on those charges. Hey everybody, real quick, this is another Law and Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to all this? Yeah, well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. They continue. Cassie Ventura and Sean Combs went to swingers clubs and they had threesomes. Miss Ventura consistently expressed interest and enthusiasm in her intimate life with Combs, including what they called freak-offs. Jane and Sean Combs had threesomes too. When Jane and Combs watched pornography together, Jane testified that she contacted two different porn stars and invited them to join her and Mr. Combs. Both Miss Ventura and Jane testified that very often they would see the same men over and over again for years. In July of 2024, Jane testified, for instance, that she suggested to Mr. Combs that they call Paul. Jane explained that she told Combs she, quote, missed Paul. When asked why she said that, she responded, "Because I did." This was a lifestyle, one that both Miss Ventura and Jane chose, one they all, as grown adults, had a right to choose. Like many aspects of sex and intimacy, it was not without its complications, its bouts of jealousy, and at times, its frustrations. But that is a hallmark of any serious romantic relationship, and that is what these were, serious, long-term romantic relationships. By the way, not surprising they're really focusing on this because, again, he was acquitted of sex trafficking. They highlight how the jury didn't find sex trafficking of Jane or Cassie, that it didn't occur. There was no force, fraud, or coercion that was used to induce these women to engage in commercial sex acts. For transportation to engage in prostitution, what he was convicted of, the prosecution didn't have to prove that violence was used or that fraud was used or threats were used. It was just, did you transport these women and men for the purposes of sex work, commercial sex acts? And obviously the jury convicted him of that. And they highlight all the jury found was that there was prostitution, payment of porn stars and escorts. And they highlight that he is a swinger, or under the Mann Act, a John. And they argue he doesn't deserve to be locked up for this. Quote, Sean Combs should not be in jail for this conduct. In fact, he may be the only person currently in a United States jail for being any sort of John, and certainly the only person in jail for hiring adult male escorts for him and his girlfriend when he did not even have sex with the escort himself. Over the last 75 years, the White Slave Traffic Act has been limited to defendants who cause interstate travel for financial gain through the business of prostitution. That Sean Combs remains in jail for being convicted of being a customer of consensual adult sex services makes this case truly exceptional. Not only is prosecuting the users of adult prostitution services inconsistent with the Mann Act, it's inconsistent with the prosecution policies of the district attorneys of Manhattan and the city attorney of Los Angeles, California, two of the three locations where this prostitution allegedly took place. In addition, Mr. Combs is incarcerated while everyone else involved in this identical conduct, his girlfriends, the cowboys, the agency leaders, the porn stars, and others, walk free, as they should. If there was ever a fact pattern that was exceptional under the Mann Act, it is this one. And then they move on to another argument, that the Department of Justice, the DOJ, has usually only charged Mann Act violations when there's financial gain. And they even cite a number of cases in the Southern District of New York, where Combs was prosecuted, that apparently involved defendants that set up a prostitution business for profit. Again, trying to distinguish between Combs' conduct And these cases, he never did any of this for profit, they argued. And they even cite the 1953 U.S. Attorney's Manual that says, quote, as a general rule, prosecution should not be instituted in the so-called non-commercial cases. And they claim the Department of Justice manual today, quote, makes clear that the prosecution of customers involved in an 18 U.S.C. 2421 offense, like Mr. Combs here, is now limited to prosecuting those who engage in commercial sex with victims of sex trafficking, in addition to those who otherwise perpetrate or facilitate human trafficking offenses. And in the absence of any sex trafficking charge, however, it is clear that the standalone Mann Act counts never would have been prosecuted. That seems true. I think you ask any legal expert, they will say if all the government had against Sean Combs was the transportation to engage in prostitution charges, just the prostitution charges, they probably wouldn't have gone after him. They coupled it with racketeering and they coupled it with sex trafficking. I agree with that. I don't think that they would have gone after him just for that. Anyway, the defense highlights how modern day prosecutions of Johns is really when you're talking about exploiting vulnerable foreigners who don't speak English well, which again is not the case here. And they highlight how the only potentially comparable case in New York is where you had a retired police officer and a former judge who apparently hired women to have sex with a male fraternal group called the Jesters. But Combs' attorneys say, while there was no profit there, there's no profit here, there was sex trafficking of those prostitutes. That's what's different. Again, Combs was acquitted of sex trafficking in this case. And here's the main point, quote, moreover, the cases which involve defendants similarly situated to Mr. Combs have been released on bond pending sentencing. In reviewing the cases across the country where the primary or sole conviction was for a violation of 18 U.S.C. 2421, the defendants who were not charged with running a prostitution business have been released pending sentencing. And then Combs' attorneys make another argument for why Combs' conditions are exceptional. And it's about him being locked up at the MDC. They say that a district court judge in the Southern District in another case basically said how bad the MDC is. As Judge Furman noted, the state of affairs at MDC is unacceptable. In so noting, Judge Furman concluded that the conditions in the MDC qualify as exceptional reasons under the statute justifying, and this was the defendant in this case, Chavez's continuing release. Judge Furman found that the conditions at the MDC are, quote, dreadful in many respects, but three warrant particular emphasis. 1. Continued reports of inordinate periods of lockdown. 2. Claims that the facility provides inadequate and or substantially delayed necessary medical care, a particular risk in this case. And 3. General issues about the conditions at the facility. These conditions have not abated in Mr. Combs' detention at the facility. As the court is aware, during Mr. Combs' incarceration at the MDC, the facility was subject to an interagency sweep that was designed to achieve our shared goal of maintaining a safe environment for both our employees and the incarcerated individuals housed at MDC Brooklyn. They're actually quoting what the rationale was. In other words, there is a significant issue at the MDC related to the safety of employees and incarcerated individuals that require outside law enforcement action from multiple agencies to address. Importantly, MDC, as a jail, has a significant law enforcement presence within its walls 24 hours per day that are equipped with investigatory and often unregulated authority. Thus, the requirement of outside law enforcement agencies to ensure safety within the MDC is an admission that serious violence, mayhem, and chaos is occurring within the MDC that requires more than a Band-Aid raid, but rather surgery. Indeed, we are aware of ongoing threats of violence and actual violence in the facility such that Mr. Combs' safety is constantly at risk. And they go on to argue, though Mr. Combs has been a model inmate for his nearly year-long period of confinement, the violent conditions are still very much a concern for Mr. Combs and is an unnecessary confinement risk given the clear precedent of multiple similarly situated Mann Act convictions where defendants were released on conditions. Now, the government, by the way, would probably disagree with that statement of him being a model inmate. Remember when they accused Combs of trying to arrange three-way phone calls and buying the use of other inmates' phone privileges to try to make sure the government wasn't listening in, that he was having these private conversations, that he was allegedly trying to contact witnesses in the case, that he allegedly orchestrated a birthday campaign to help his public image while he was locked up. So if we hear a government response, I'm sure they're going to say something about that. Then the defense highlights he's not a risk of flight, he's not a danger to the community, which, by the way, I think are real key points here. But they seem to echo a lot of the same arguments that they have already stated to the court. And remember, they haven't been successful in the past. That he voluntarily came to New York last year to surrender himself to authorities, that he gave up his passport to his attorneys 6 months before his arrest, paid off his mortgage on his Miami home so it was free and clear for him to stay at while out on bond. He was just acquitted of the most serious charges that he was facing, which, by the way, carried decades, if not life in prison. That he's not a risk of flight. That's the basic argument. Now, when it comes to the danger argument, that is key. Why? Judge Subramanian had said after the verdict that the reason he was denying bail was because of Combs' violence, that his own attorneys admitted he was violent during the course of the trial. Well, here is what Combs' defense attorneys argue about that. Quote, the court noted that the defense admitted a history of domestic violence as to Miss Ventura and that he struck Jane twice in June 2024. However, we strenuously object that Mr. Combs poses a danger to the community, aside from a single instance on June 18, 2024, where Mr. Combs was provoked by Jane through her own acts of violence. There was no evidence of any acts of violence in the last 7 years. Indeed, the jury notably rejected the government's argument that the June 2024 incident constituted coercion when it acquitted Mr. Combs of the sex trafficking charge. Also, prior to his arrest in this case, Mr. Combs enrolled in a domestic violence program in which he participated until he was arrested and incarcerated in connection with this case. If released on conditions, Sean Combs will not be violent to anyone. As we said in court, this jury gave him his life back, and he will not squander his second chance at life, nor would he do anything to further jeopardize his 7 children not having a father and 4 of his children not having a parent at all. The court can fashion any set of conditions, and Mr. Combs will abide by any condition to make the court comfortable that Mr. Combs will not be violent toward any person. And that is when they propose the following bail package. That Combs will sign a $50 million bond secured by his home in Miami, that the bond will be co-signed by 3 financially responsible people, that Combs will reside in his home in Miami, that his travel will be limited to the Southern District of Florida, the Southern District of New York for attorney meetings, as well as airports that are necessary to travel between the two, that he will be placed under the express supervision of the U.S. Pretrial Services Agency, that he will report to that agency as directed, that his passport will be surrendered to pretrial services, that he shall not apply for any other passport, and they even highlight that the court can add other conditions too. Home detention, private security approved by the court, mental health treatment. He'll agree to it all. Now, let me tell you, we kind of previewed that this all would happen, this argument would happen, this new bail package would be presented when we spoke a few weeks ago to renowned bail bondsman, to the celebrities, by the way, to the stars, Ira Judelson, who apparently had been working with Combs' team behind the scenes on working to secure his release. Here's what he said about a new package after the verdict.
When Mark reached out to me afterwards, we started thinking about putting another bail package together.
And what is that bail package and by the way, is this a bail package that you think could be submitted again even after the judge just denied bail?
Well, the judge denied bail based on the statute, and the statute stated a certain amount of information that part of the Mann Act that, was not eligible for bail. There are certain circumstances that can be done. We're going to regroup again. I know that they were going to go talk to Mr. Combs again and see what happens there. They have the October 3rd date. I don't know where he stood. As of the other day, he wanted to get out. I don't think anybody wants to be at MDC where he is. We're going to reconvene and see what happens, at a later date. We could go back with another package.
Okay, so with all that in mind, and again, at the time of this recording, I don't see the government's response to this, but here's my take. Now, Combs is obviously in a better position to argue for release now than he was in the past. I thought that after his acquittal, this change in circumstances, that he could be released. The Mann Act convictions alone, given the facts presented in court, I think the defense made a compelling argument that he should be released, not facing as serious charges that would have justified, a concern of a risk of flight. He's no longer charged with the violence of racketeering and sex trafficking. But remember, the judge was very persuaded by the violence aspect that was a part of this case. The judge has latitude, discretion here when it comes to bail and bail conditions. And he received letters immediately after the verdict opposing bail. And I think a lot of the defense's arguments are compelling, particularly citing case law about other people who were released. But the judge could be persuaded that these were multiple violations of the Mann Act with respect to both Jane and Cassie. These weren't isolated incidents. Multiple men, multiple payments, multiple dates, multiple transportation. The violence, the drugs, those factors in the case may not necessarily have to be separated from the bail analysis, despite the fact that they weren't really required elements of the charges that he was convicted of. And you can make the argument, sure, he was acquitted of sex trafficking of Jane and Cassie. The jury might say he didn't use force, fraud, or coercion to induce them into commercial sex acts, but violence still may have occurred. The judge might be persuaded by that. And I don't think at this point, my personal opinion, I don't see the judge changing his tune. I don't see him being persuaded by these arguments. But look, for Sean Combs, obviously he wants some sort of release from jail before sentencing, because while the judge could technically sentence him to time served or 20 years, both seem highly unlikely, it seems that he would be sentenced to some additional time in prison. And obviously Sean Combs wants some time out of prison, some time out of detention before he's ultimately sentenced. Now, we'll see what the judge does. I could be wrong. We'll wait and see. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.